Well, Young Thug's attorney, Brian Steele, he made an attempt to get Judge Glanville removed from the bench after there was a secret meeting held where Lil Woody was said that he was coerced or into testifying, and if he didn't testify, they were going to charge him. And this secret meeting where the lawyers, the defense wasn't allowed in the room, they wanted him removed from the bench, but this happened.
Having a closer look into the legal showdown in the YSL RICO case. Today, the Fulton County Superior Court judge denied Young Thug's lawyer's motion that the judge step down from the case.
But the fallout from the judge's alleged secret meeting with the witness is far from over. Newsnet reporter Rob D'Arienzo is here with a breakdown of another day of a testy day, we should say, in court. Rob.
Yeah, that's right, guys. And at the center of this meeting that the prosecutor and judge had with witness Kenneth Copeland in private without telling Young Thug's lawyer and the rest of the defense. The rapper's lawyers argue that the judge in this case is now a witness in this case.
I'm going to deny the motion at this point in time.
Chief Fulton County Superior Court Judge Ural Glanville remained defiant in his courtroom Tuesday, tossing two motions to get him recused. The defense argues a meeting in the judge's chambers with prosecutors and witness Kenneth Copeland makes an impartial trial impossible.
Those kinds of meetings are highly disfavored. In fact, they really should never happen but for the most, kind of emergent circumstances.
GSU law professor Anthony Michael Kreis says the contempt charge the judge slapped Thug's lawyer Brian Steele with is also highly unusual. Steele accused the judge and DA of essentially coercing Copeland into testifying by threatening him with jail time.
So I've added this court to the witness list. I plan on calling the court as a witness in the trial.
Kreis says that just adds so many layers to an already complex case.
You can't have a judge sitting as an adjudicator or as an impartial decision maker at a criminal trial who's also witness.
Judge Glanville had ordered Steele to spend the next 10 weekends in jail for bringing up that meeting with the witness in a testy exchange, but a higher court blocked that. While Steele has asked for a mistrial several times, Kreis says it's not going to help his client.
And by and large, a mistrial would mean that they're probably going to be tried again. And that means a lot more time in court and a lot more time in pretrial detention.
The professor says the defense can also ask a higher court to review the motion to recuse Glanville through what's known as a writ of mandamus.
When I cross-examine Mr. Copeland, when that day comes, I'm going to ask him about how much pressure, if any, the court put on him.
And the judge has agreed to release the transcript of that meeting with the witness with redactions to the defense. But with all of this, the jury most likely will not return to the courtroom until next week. Guys.
Just adding to how long this trial has been going on. It's been one thing after another. It just
so
keeps
many twists and turns.
Yeah.
It's like a movie.
Yeah.
Oh, my goodness. All right. Thanks so much, Rob.
Thanks, Rob.
Well,
So the judge denied their ability to get him recused from the bench. So now they can, they can take it up to a higher court to try to get him off, to let the higher court hear what happened. But in court the other day, Brian Steele and the judge went head up, and Brian Steele this time, he wasn't backing down. He was basically explaining why he wanted him recused and what's going to happen next. So check this out.
First order of business the court needs to take up this morning. I have two motions to recuse, one filed by defendant Jeffrey Williams that was filed yesterday and handed to the court at the end of the business day. Another one has been filed under the same indictment, just indictment 22 SC 183572. And I want to say that motion to recuse has been filed on behalf of Miss Kayla Bumpus. Can I get the lawyers or the principal lawyer for that particular case to identify themselves for purpose of the record?
Judge, good morning. Gabe Banks.
Good morning, Mr. Banks.
Her legal team is also here. Mr. Collins, Ms. Novey, Ms. Mormon, and Mr. Winchester.
All right. Good morning, counsels. Okay. As it pertains to your motion, Mr. Banks, and on behalf of everyone that is here, I'm going to just take up the issue of the recusal. I'm going to defer the issue of the motion to quash at this point in time, okay? So I'm not going to take up anything. I can't do it anyways because the rules require me to go ahead and deal with the motion to recuse to begin with. So I've ceased any other business, and that's why I had Mr. Chamberlain reach out to you last night and counsels for you all to be here this morning so I could take this up. Your motion actually was filed last Friday at 10:40 p.m. It didn't appear in the system, however, as sometimes Odyssey happens, until sometime on Monday evening. So when I started to read Mr. Steele's affidavit last night, we were put on notice that there was possibly another affidavit out there and another motion. So that's why we had to call you, okay? So that's how we got here with this. Or else, did you all attempt to send me independently another a copy of that, or?
We did not, Judge.
Okay, no harm, no foul, no. So, no, I just wanted to know if you had attempted to do so, because we would have certainly, had we known that, pulled you in on Monday morning, which would have been the closest time that I could have heard your particular motion. So just from a time aspect, I just wanted to account for that. Taking a look at and this applies to both motions that have been filed to recuse the court or disqualify the court. Recusal by a Superior Court judge is governed by Uniform Superior Court Rule 25, etc. Rule 25.1 provides that all motions to recuse and disqualify a judge presiding a particular case or proceeding shall be timely filed in writing, and all evidence thereon shall be presented by accompanying affidavits, which shall fully assert the facts upon which the motion is founded. Filing and presentation to the judge shall not be later than 5 days after the affiant first learned of the alleged grounds for the disqualification, and not later than 10 days prior to a hearing or trial, which is the subject of the recusal or disqualification, unless good cause be shown for the failure to meet such time requirements. And that is cited in Georgia Uniform Superior Court Rule 25.1. So I'm applying that to both sets of motions to recuse. And applying this rule, Georgia courts have held that when a motion to recuse is filed, the trial judge shall immediately, 1, determine the timeliness of the motion, 2, the legal sufficiency of the affidavit, and 3, the legal sufficiency of the grounds, and has no power to do anything else. And that is Robinson versus the state, 332 Georgia Appeals at 242-41. The 3 threshold determinations that the trial judge must make in regard to a motion to recuse are whether it's timely filed, whether the affidavit made in support is legally sufficient, and whether some or all the facts set forth in the affidavit are true, recusal would be warranted. And that is Dacker versus the state, 300 Georgia 74-77, 2016. The judge finds any 3 of the conditions have been met. No, I'm sorry, take that back, strike that. If the judge finds that all 3 conditions have been met, he must refer the motion to another judge to hear the motion. But if any one of the conditions is not met, there is no error in denying the motion. And motions to recuse are viewed and considered by the appellate court for abuse of discretion. Accordingly, the court is going to address each one of the factors as it pertains to both Mr. Steele's motion and, for shortness, Mr. Banks' motion. I find both motions were timely filed. I find that Mr. Steele's motion was in fact filed on this past Monday, which would have been the 17th of June. I find that Mr. Banks' motion on behalf of Ms. Bumpus was timely filed, as it was filed on the filed on the 14th of June at 10:40 p.m. Secondly, I find that in addressing the legal sufficiency of the affidavit. That means, was it sworn? Was it sworn before a notary? Is in proper form? I find Mr. Williams and Ms. Bumpus's motions to be, or I should say affidavits to be in proper form. The third thing that the court has to review, and like I said, I reviewed, is the legal sufficiency of your grounds of the motion. And here's where the court finds that upon a review of Mr. Steele's motion and affidavit, as well as Mr. Banks' motion and affidavit, that both contain assertions bare assertions and legal conclusions which aren't sufficient for the court to grant your motion at this point in time and refer it to another judge for it to be heard. So I'm going to deny the motion at this point in time. I invite you all to look at Baptiste versus the state. Just because adverse rulings have been made doesn't mean that the court stops the trial. So I'm going to make that. I'll reduce both of the motions to recuse to an order, and I will file that so you can take whatever steps you need to necessarily after that. But I don't get into anything about the affidavit itself, argument on that. I just have to read it. Those are the only three things I do. And then if I find it to be not sufficient on its face, I go for it. I just make the ruling at that point in time, let you all take it up. No, I won't grant a motion for a certificate for immediate review. And that's where we are at this point in time. Anything else, Mr. Banks?
If I could just briefly be heard, Judge.
Sure.
Court, please. And I'm not trying to, I understand the court's ruling and we'll proceed as we see fit. I do take issue with the court's characterization about the legal insufficiency of the affidavits.
Well, that's why when it was reviewed on appeal,
Sure.
it can certainly be, I mean, the appellate court will review my ruling for abuse of discretion.
Certainly
Okay.
understand that, Judge. And in stating that, Judge, I would just say that one of the issues that is raised in our affidavit, because our motion to recuse is to recuse you from the contempt proceeding, not the underlying criminal case in which Your Honor is presiding. And so we really don't have an issue or standing to even challenge that. And so to the extent that there is a contempt proceeding that is set for the 25th, Your Honor, you are a witness to that proceeding. And so because you were a witness.
I don't believe you. I'm not going to get into any argument, but I can't. So that's your assertion at this point in time. And like I said, when that is taken up, I'll consider it. I also remember I still need to rule on the issue of the motion to quash. So I may, depending upon what I decide to do at that point in time, other things may be ripe. Okay.
Do you want to hear about the motion to quash, or you want to take
No, not yet, sir. I'm going to take up the motion to quash after I finish. We finish the direct of the current witness.
Okay.
And to other issues that have been raised, as I've told some of the other lawyers here, there is a transcript of what occurred in the ex parte matter. I will, in fact, I'll authorize defense counsel. I'll do a privilege review and see what needs to be disclosed in terms of impeachment and/or Brady, and for that, and I will do that. And then so if that pertains or if that issue affects you, then certainly that may be something that at the appropriate time you'll be able to have a look at.
Well, I appreciate the court's time. We would certainly rely upon our brief and our motion, and that's a part of the record.
Okay. All right. But I will reach out. The court will reach out to you on two things. One, the ability to take a look at the ex parte transcript and review it for the appropriate parts that the court will authorize. And then also for the, I'll re-notice you because I know that it's supposed to be done this Tuesday, but I doubt that we'll probably have it this coming Tuesday.
If I just may say, again, Judge, I know I've already said it as it concerns the issue about you being a witness to the proceeding. We don't believe that that's a bare allegation. We believe that's that would be an established fact at the hearing. We also.
But I can't take it. It's not something that I can argue with you at this point in time.
I'm not trying to argue.
No, sir. You are an advocate for your client. Sure. That's the only thing I can say, but I'm not going to take up that issue right now. It's part and parcel. You made it part and parcel of the motion to recuse. So I'm saying that at this point in time, I've made my ruling. You've said what you need to say in terms of what your thoughts are. I'm going to reduce it to an order, and you can take what you want to after that. Okay.
All right. Thank you.
All right. Thank you, sir. All right. Mr. Steele, similarly, I'll reduce what I have mentioned to in an order, and you will be able to take it up as you see fit. I'm not going to grant a motion to a certificate of immediate review. Anything else?
I have read Baptiste versus State. I've read all the cases that I believe are applicable. I'm, best I can. But specifically, if the court would reconsider, and if nothing else, the Honorable Keith Adams and my joint affidavit in paragraph 12, we assert not a bare assertion or a legal conclusion, but we make facts that we specifically adopt from the Honorable Attorney Winchester, Collins, Banks, Nove, and Mormon's motion, where a person that they represent was in a meeting, ex parte, with the court and others, and the prosecutor and a witness, and specifically they wrote in a pleading and under Parish, which is P-A-R-R-I-S-H versus State, which is 362 Georgia Appeal, 392 Division 1, 2022. The lawyer's pleading on behalf of the client becomes a statement of the client. And they said that this court got involved with speaking with Mr. Copeland and assisted in Mr. Copeland testifying against Mr. Williams. So I've added this court to the witness list. I plan on calling the court as a witness in the trial. I added lawyers Hilton and Love from the district attorney's office to the witness list. And when I cross-examine Mr. Copeland, when that day comes, I'm going to ask him about how much pressure, if any, the court put on him. And you're going to be the one instructing the jury. And I just can't imagine how that's fair to Mr. Williams. So I just ask you, I'm not abandoning anything in the joint affidavit from the Honorable Attorney Adams and myself, but if you would just look at just even paragraph 12, again, if you didn't consume it entirely, I don't believe that meets a legal conclusion or a bare assertion. I ask the court to recuse.
I've read your affidavit, Mr. Steele, and I've consumed everything on it, and that doesn't change my ruling at this point in time, respectfully.
I also, on the transcript, I'd like the recordings and the transcript, and I object to the court going through it and deleting, because to me, the way I understand it, there is zero privilege. So I don't understand
I'm not going to, Mr. Steele, I can't argue with you about anything such as I've made my ruling, okay? If you have some other basis to ask for the recordings or anything like that, you're going to have to put those in some other pleading. But at this point, Ms. Weaver is going to prepare the record. She does that. And like I said earlier, The record should be ready soon. And you all, as a defense group, will have the opportunity to take a look at that particular ex parte transcript that was done in chambers, less anything that is totally that the court considers to be privileged. And I'm going to let you do that before you examine Mr. Copeland. So you'll have everything that you have at that point in time.
Thank you.
All right.
So as you can see, this whole court proceeding is a mess. They don't want to call a mistrial because this already has been like the longest trial in the history of Georgia. So they don't want to redo this all over again. So now Judge Glanville, he's created a whole crap just crap show, you know, allowing this meeting to be had, and the lawyers are doing what they're supposed to do. So Brian Steele was saying, listen, I don't trust you. I don't trust you to instruct the jurors because I don't know if you just totally against my client. I don't know if we're getting a fair shake here because we wasn't included in that meeting. So now Judge Glanville, he's being forced to release the transcript from the meeting that took place, right? So now the other lawyers that's representing the other defendants they're there, and he's saying, well, we're not going as far as Brian Steele was going for his client, but we don't like the fact that the meeting was held, and we're holding you accountable to this standard. So you got a chance to see both lawyers get up there and explain themselves. So now Judge Glanville's basically saying, and I believe that he's going to be replaced because it makes the court look real bad. If the trial is being done in bad taste, it's being played out before the world where everybody can see it and all the lawyers can voice their opinion on it. Judge Glanville messed up when he put Brian Steele in contempt, and you had so many lawyers come out in solidarity, so that made the court look bad. So a lot of the judges right now is upset with Glanville because he's not handling these proceedings in the manner in which he should handle it. He's causing an embarrassment to the bar and the Judges Association, in the way that this case has now went international in the news, and when after the meeting, the way he conducted himself and not following the law, and that's why Fannie Willis, not Fannie, but the judges, the lawyers went and they got they basically went and got a fast meeting with the Georgia Supreme Court, and they got him off where he didn't go to prison, and they got him off. The judges ruled in their favor right away because they knew that Judge Glanville was breaking the law. He was upset. He was tight because of the meeting, so he just started doing things on his out of his own. He wasn't going by Georgia's law, so he's brought embarrassment now to the bench. So now they're in a catch-22 because do you get rid of him and have to do this all over again, or do you keep him and now you cause a problem? So it's just like, you know, I think no matter how it goes, it's going to, as right now it's panning out, and you know, the YSL crew there is panning out in their favor. But as more of this come out, I'll report more of this. Like I said, you young people, man, please stay out the street because this is the flip side of the game. You know, this is the flip side of the game. You know, you in jail, you got these people fighting for your life. You know what I mean? For choices that you made when you was out here in the streets, man. So we understand with the YFN Lucci case, they had similar things that, you know, that went on. But like this whole thing is just like a crap show, man, down there in Georgia, man. You know, so like, listen, if you made it this far in the video, hit that like button, subscribe to Street Media TV. Leave your comments in the comment section. Let me know what you guys think about this, man. Remember, I love y'all. Till the next time. Peace.